All right, a name just became a liability, not a political liability, a legal one. The kind that doesn't wash off in a press cycle, doesn't dissolve in a favorable news segment, and doesn't disappear when the administration moves the conversation somewhere else. Pam Bondi just became the kind of problem that compounds. And the people inside Trump world who built their architecture around her aren't talking about it the way they should be. Because what happened this week wasn't a stumble. It was a structural fracture. And the shockwave is still moving. I've been in the documentation since Monday. There are things in the record that the prime time coverage hasn't touched. Not because they're hidden, because following them requires sitting inside the filings long enough to understand what you're actually looking at. Most people aren't doing that. I am. And what's in there changes the shape of everything the administration thought it had secured. Here's the part nobody is saying loudly enough. This isn't one bad ruling. This is a sequence. And sequences have momentum. Quick framing first. Bondi came into this position carrying a specific kind of political weight. She was not chosen for her litigation record alone. She was chosen because of what she represented inside the coalition that built this administration's legal strategy. A proven loyalist. A familiar face to the donor infrastructure. A name that communicated directional commitment without requiring explanation. That's the architecture of her appointment. It was never purely about prosecutorial philosophy. It was about alignment. About sending a signal through a cabinet selection that the Department of Justice would bend toward the administration's priorities in ways that prior iterations had resisted. That signal got read by a federal court. And the court wrote back. What the court wrote back is now permanent. It lives in the record in language that is specific, documented, and anchored to the period of her leadership in ways that her name doesn't have to appear in the operative sections for anyone reading carefully to understand exactly who the court is talking about. The footnotes do the work the operative language leaves unspoken. And federal courts know exactly how to use footnotes as precision instruments. That's what makes this different from the usual political turbulence. Political turbulence fades. Court records don't. Let's go back to how this sequence actually started. Because this week's ruling didn't materialize from nowhere. It is the product of a chain of events that began 14 months ago and built to this moment through a process most of the coverage treated as background noise while it was developing. 14 months ago, a pattern started forming inside the department's litigation posture. Decisions in specific case categories started moving in directions that career attorneys inside those divisions found difficult to explain on purely legal grounds. Not one or two decisions. Not outliers that could be attributed to prosecutorial discretion. A documented pattern across 23 separate matters in a 14-month window. That documentation became the spine of the state coalition's initial filing. The coalition took a risk with their theory. They didn't just argue that specific decisions were wrong. They argued that the framework producing the decisions was compromised. That the department's internal deliberative process had been restructured in ways that made genuine independent legal judgment impossible in the affected categories. That's a harder argument to make than a standard policy challenge. Courts don't like reaching into executive decision-making. The separation of powers instinct runs deep in the federal judiciary. This court reached in anyway. And what it found when it got there is what produced the shockwave. Now here's the twist that's breaking open inside Trump world right now. Bondi's position was always premised on a particular kind of insulation. The assumption that loyalty to the administration constituted protection from the administration's legal exposures. That if the department moved in directions the political leadership wanted, the political leadership would absorb any institutional fallout and shield the appointees who executed the strategy. That's how the loyalty network is supposed to function. You deliver the outcomes. The top of the structure covers the exposure. That model just broke. Openly. in a federal court order with a footnote on page 29 that places her leadership directly in the frame of the court's structural findings. The administration is not covering the exposure. It filed a 31-page opposition that spent 29 pages arguing the court didn't have authority to issue the remedy, and 2 pages addressing the actual facts the court documented. 2 pages. That ratio is not a defense of Pam Bondi. That ratio is an administration calculating that its best legal path forward runs through procedural arguments and not through the factual record, which means the factual record stays standing, uncontested in any meaningful way. And Bondi stays inside it. That's the collapse. Not a dramatic resignation moment, not a public confrontation. A quiet, documented abandonment expressed through a legal brief that chose to spend its time arguing scope rather than disputing what the internal communications actually showed. When your own administration's legal team won't stand on the facts of your conduct in 31 pages of opposition, you are not being protected. You are being preserved as a procedural argument while the factual damage accumulates around you. Let's sit with what the factual damage actually consists of. The court reviewed sealed internal communications, not press briefings, not public statements, not the version of events the department's spokespeople have been constructing for external consumption. The actual internal record. Emails, memos, strategic discussions among senior leadership about how to approach litigation decisions in the affected categories. And after reading those communications, the court used a word to describe what it found. Predetermined. Not aggressive. Not politically motivated in a vague sense. Predetermined. The court found that the conclusions in a series of litigation decisions were reached before the legal analysis that was supposed to produce them. The legal reasoning was constructed after the outcome had already been decided. The analysis was reverse engineered to support a destination that had been chosen by other means, through other considerations, reflecting other priorities than the legal merits of the matters themselves. That is the finding that lives in the record now. That is what Bondi's leadership produced on the court's documented read of the department's internal communications during her tenure. And the administration's formal legal response to that finding was 2 pages. Let's talk about what predetermined actually means in practice, because the word sounds clinical until you understand what it describes. Think about a career attorney in the Civil Rights Division, someone who spent years developing expertise in a specific category of enforcement, who knows the relevant precedents, knows the regulated entities, knows the communities the enforcement framework exists to protect. That attorney brings a matter to senior leadership with a recommendation grounded in 14 months of factual development and 3 circuit precedents that support a clear legal path forward. And the answer comes back as a direction that doesn't engage with the precedents, doesn't dispute the factual development, simply redirects the matter in a different direction without a legal rationale that matches the weight of the analysis underneath it. That attorney now knows something, not as suspicion, as operational reality. The decisions aren't being made at the end of the legal reasoning process. They're being made before it starts. The analysis is theater. The outcome is fixed. And the attorney's professional judgment is being processed through a mechanism that was never actually designed to receive it. That's what the court documented. Not the high-level structural description in the operative sections, the texture of it. The way it functioned day to day inside the department's deliberative process for 14 months. And now that texture is in a federal court order where it doesn't expire, doesn't fade, and cannot be walked back by a press statement or a Fox News appearance. Now the shockwave part. The part that makes this specifically a Trump world crisis, and not just a Bondi problem. The administration built its second-term legal architecture on a specific theory, that the executive branch's control over prosecutorial discretion was broad enough to accommodate political alignment in case selection and enforcement priorities without exposing that alignment to meaningful judicial scrutiny. That the courts would protect the zone of executive discretion even when the exercise of that discretion reflected obvious political calculation. That the separation of powers doctrine was shield enough. The court just tested that theory and found its limits. Not by rejecting the separation of powers argument entirely. The court acknowledged the gravity of the constitutional question. It wrote 3 paragraphs specifically explaining why it was not doing what the government would say it was doing. But it found that the documented evidence of predetermined outcome orientation placed this situation outside the zone of deference the separation of powers doctrine was designed to protect. You can't claim judicial deference for a process the court finds wasn't actually operating as a process. Prosecutorial discretion protects genuine, deliberative judgment. It doesn't protect a system where the judgment was completed before the deliberation began. The court drew that line explicitly, and it drew it with 14 months of documented evidence underneath it. That distinction is what makes the shockwave effect real. Every future attempt by this administration to use the prosecutorial discretion shield now has to contend with a circuit level proceeding in which a federal court examined the internal communications and found the discretion wasn't being genuinely exercised. That doesn't bind other courts as formal precedent in the way an appellate ruling would, but it lives in the record as a factual template. It shows other courts and other coalitions what kind of documentation you need, what kind of pattern analysis you build, and what kind of evidentiary development produces a finding that survives the government's procedural response. This ruling is a map, and it's publicly available. Now let's talk about the voices entering this proceeding that aren't getting the coverage they deserve. The amicus activity around the appellate proceedings has been significant in a way that partisan commentary keeps missing by filtering it through political identity rather than professional credibility. The most important voice isn't a Democratic-appointed former official. It isn't a liberal law professor. It's a former Solicitor General who served under a Republican administration. A person who argued on behalf of the United States government in front of the Supreme Court. A person whose professional formation and ideological orientation should make them a natural ally for an executive discretion argument. That person filed a brief arguing the structural injunction should be upheld, not in a sweeping, ideologically charged way. Narrowly. Precisely. With citations to precedents the government's own brief failed to address. The argument is specific. When a court reviews internal executive branch communications and finds documented evidence that a category of decisions was being made on a predetermined basis rather than through genuine deliberative legal judgment, the structural injunction remedy falls within the court's equitable authority. The separation of powers doesn't protect what it found here, because what it found here isn't the discretion the doctrine was built to insulate. When a Republican administration Solicitor General makes that argument against you in federal appellate proceedings, you are not winning the institutional credibility fight. You are losing it from a direction that your usual messaging infrastructure has no framework to address. Because the talking point requires framing this as partisan judicial activism against a Republican administration. That frame doesn't work when the voice affirming the court's authority is someone whose professional life was spent arguing for executive power under a Republican flag. That's the institutional dimension of the shockwave that isn't being processed correctly by anyone covering this as a political story. Here's the operational reality inside the department right now. The 60-day compliance window is running. The court required the DOJ to present a documented framework demonstrating how decisions in the affected categories will be made going forward. Not a policy announcement. Not a reorganization of letterhead. A documented process. Identified personnel with defined roles. Auditable records showing the reasoning chain behind enforcement choices. Clear accountability lines that a reviewing court can follow from decision back to deliberation. Building that in 60 days while managing the appellate petition, the congressional oversight calendar, the press environment, and the internal culture fracture that a finding like this creates inside a department full of career professionals who take institutional integrity seriously. That's not a management challenge. That's a stress test. And stress tests reveal what the underlying structure is actually made of. The career attorneys inside the affected divisions are not invisible to what's happening. They read the ruling. They understood the finding. They know that the internal communications the court reviewed were produced during a period when they were doing their jobs, and watching the outputs of their work get redirected through a process that the court just called predetermined. They are now operating inside a compliance framework that requires them to document the very deliberative process that a federal court found wasn't functioning as advertised. The documentation requirement cuts both ways. If the deliberative process is now genuine, the documentation shows that, and compliance is real. If the documentation is performative, if the compliance framework is cosmetic, and the underlying decision pattern continues, the court has a 9-month review proceeding scheduled in September with a third-party monitoring organization already publicly committed to submitting documented observations about the pattern of decisions between now and then. A judge who spent 14 months building an evidentiary record from sealed communications is not a judge who will be satisfied by a compliance framework that looks correct on its face while operating the same way underneath. That's the trap the administration is inside. Real compliance means changing the actual decision process, which means the political outcomes the department was producing stop being produced, which defeats the purpose of the appointment architecture that brought Bondi into the role in the first place. Nominal compliance means producing documentation designed to satisfy the court's form requirements while leaving the substance unchanged, which means the 9-month review proceeding is going to get a documented pattern that looks remarkably like the pattern that generated the original finding. There is no clean path through this. Both options carry costs the administration wasn't pricing when it built the strategy. Let's talk about what the human dimension of this looks like. Not the legal architecture, the actual people. There are communities in the affected enforcement categories who have been waiting on federal action for years. Not quarters, not billing cycles, not investor relations timelines. Years. People in environmental enforcement matters who've been watching contamination in their water systems, while the federal enforcement process that exists precisely to address those situations has been producing the kind of outcomes a court just called predetermined. People in civil rights enforcement matters who've been watching documented violations persist, while the department's response has been shaped by the orientation the court's internal communications review revealed. For those people, the ruling is both a validation and a complication. Validation because what they suspected about how their cases were being handled just got documented in a federal court order that won't disappear. Complication because the stayed matters. The 3 specific proceedings the court halted pending compliance include categories of cases that directly affect communities who were already at the end of a long wait. Their wait just got 60 days longer at minimum, possibly much longer depending on how the compliance proceeding develops and whether the appellate court intervenes in the stay petition. And the reason their wait got longer is that the department that was supposed to be resolving their matters has been placed under judicial supervision because a court found it wasn't making decisions the way it was supposed to. That's not an abstraction. That's time in people's lives that the system consumed without delivering what the system is built to deliver. Now the part that reaches past this administration and past Bondi and past this specific moment. Every attorney general operates inside the tension between political leadership and institutional independence. The executive branch appoints the leadership. The leadership sets enforcement priorities. Priorities reflect the values and commitments of the administration that holds the appointment power. That's how democratic accountability is supposed to work. The voters choose the president. The president chooses the department heads. The department heads direct the institutional machinery. The question is where direction ends and distortion begins. where legitimate priority setting transforms into the kind of predetermined orientation the court documented here. The line isn't always visible from the outside. It requires access to the internal communications, the deliberative record, the pattern of reasoning that precedes the pattern of outcomes. This court got that access. It found the line had been crossed, and it wrote an opinion explaining where it found the crossing and what the evidence showed that made the finding unavoidable. That opinion is now the reference point, not just for this administration, for every administration that follows. Every attorney general who sits in a strategy meeting about how to approach a category of cases is now sitting in the awareness that internal communications from those meetings are potentially producible to a federal court that finds sufficient documented pattern evidence to justify the production. That awareness doesn't chill good faith legal deliberation. Good faith deliberation produces communications that read like good faith deliberation reads. The court knows what that looks like. It said so explicitly. The problem was that what it found in the sealed record didn't look like that. It looked like something else. And it said what it looked like, precisely in 47 pages. So where does this land for Bondi specifically? Not the department, her. The collapse isn't happening in a single dramatic moment. It's happening in the architecture, in the footnotes, in the amicus briefs, in the ratio of pages of 31-page opposition spent on procedure versus facts, in the Republican Solicitor General filing against the government's position, in the career attorneys who are going to spend the next 18 months making decisions inside a framework that requires them to document the reasoning process that their leadership's prior conduct made the court distrust. That's where we are. No exit through procedure that doesn't require winning on facts the government isn't contesting. No appellate relief that doesn't require distinguishing circuit precedent the current brief hasn't addressed. No compliance path that simultaneously satisfies the court's requirements and preserves the political outcomes the appointment architecture was designed to produce. The shockwave is still moving. This week, it reached the appellate filings. September, it reaches the 9-month review. 18 months from Friday, it reaches the end of the monitoring period where a judge who has been watching the documentation for a year and a half makes a determination about what he found. That's the timeline. That's the trap. And that's the thing nobody in the political coverage is sitting with long enough to describe accurately. The administration thought the separation of powers was a wall. The court found a gap in it and walked through carrying sealed communications that described exactly what was happening on the other side. And it published what it found. Publicly. Permanently. With a footnote that doesn't need her name because the period of her leadership is specific enough. Wednesday's compliance conference will generate a docket entry. September generates a hearing. The appellate petition generates a ruling inside the next 3 weeks, if it's going to matter before the compliance deadline. I'll be in the documents. Because the documents are running 3 news cycles ahead of the commentary right now. The filings are moving. The amicus activity is moving. The compliance clock is moving. The story isn't waiting for the coverage to catch up. And what started with a 47-page court order on a Friday afternoon has approximately 17 months left on the judicial clock before anyone gets to call this chapter closed. Stay connected. Because the shockwave doesn't stop moving just because the cameras moved on.